Welcome everyone. This is Amer from UCounsel. Today we'll talk about Amendment of Pleadings, which is covered under Rule 26 of the Rules of Civil Procedure in Ontario. We begin with our usual disclaimer that this course is not legal advice. If you have any specific questions regarding your issues, you should contact a lawyer or a paralegal, or contact the Law Society of Ontario for a referral. What is meant by Amendment of Pleadings? The basic principle you want to keep in mind is that you can only get from a court what you have asked for in the pleadings. What does that mean? If you have asked for damages of $100,000 in your pleadings, and at trial, you are hoping that because your case was so good, the judge will award you $250,000, that's not going to happen because you have only asked for $100,000. So even if the judge believes that you could have gotten more damages or you should have been entitled to more damages, because you have not asked for it, you will not get it. That's the basic thing. So you have to consider pleadings and what you're asking to be contained in the pleadings within the four corners of those pleadings. Similarly, let's say that you want the court to award you damages for mental pain and suffering. But if you do not ask for damages for mental pain and suffering, if you do not plead that tort of mental pain and suffering, you will not get damages for that. If you do not ask for punitive damages, you will not get punitive damages. So the basic thing that you want to understand is that the court will only grant you something that is contained in your pleadings. And if it's not in the pleadings, you will not get it. So if you understand that, then you realize that your pleadings are very important, whether it's statement of claim or statement of defense. The documents are important, and what you are asking the court to do, either to accept certain facts as true or to provide you certain remedies, you have to ask for it. So just a quick reminder for those people who do not realize what pleadings is. Pleadings are statement of claim, statement of defense, reply, third-party claim, cross-claim, etc. Those are the basic documents in which parties lay out their position for the court in terms of claim, in terms of defenses, and in terms of claiming any remedies from other third parties. So why you may need to amend pleadings? There could be multiple reasons why you may need to amend pleadings, and I'll give you some examples. Number one, you may need to add, delete, or substitute parties. So you started a court action and then you realize at some point that there are additional parties that you want to add as defendants in your court action, and then you have to amend your pleadings to add those parties or that party into the court action. You may have misspelled the party's name. And so when you misspell a party's name and when you have to correct that spelling mistake, then that will be considered a substitution of parties. So you will have to amend your pleadings to actually correct the spelling of that party's name. Similarly, you may realize that you no longer need a party, or you think that the party that you have named as a defendant should not have been a party, and you want to delete that party's name. You will have to amend the pleading to get that. Similarly, you may have made mistakes in your pleadings. You may be looking for damages for $250,000 and you may have inadvertently put $25,000. So there's a mistake and you want to correct it. You will have to amend the pleading to fix that. You may realize that there are new facts that are relevant to your case that you have not pleaded previously, and you want to add those facts into your pleadings. You may need to amend the pleadings. Similarly, you may have causes of action. Causes of action is something, the legal basis of something that you're asking the court to do. For example, as I said, tort of mental pain and suffering could be a cause of action that you have not pleaded. Or you may have pleaded negligent misrepresentation, but you want to add fraudulent misrepresentation into the cause of action that you are asking the court to grant you. So you may need to change, add, or delete causes of action. And all of these circumstances are ones in which you will have to amend the pleadings. And then again, you may want to change the amount of damages you're claiming. You may add damages or reduce damages or delete damages. You will have to amend your pleadings to do that. So where does the right to amend a pleading, pleadings come from? This is contained in Rule 26.01. And the most important part of the rule that you want to understand is the language that is used in this rule is called the court shall grant amendment unless. Let me take you to the rules. We'll quickly read it. 26.01 says, on motion at any stage of an action, the court shall grant leave to amend a pleading on such terms as are just, unless prejudice would result that could not be compensated for by cost or an adjournment. So what is the important part is that the rules require the judge to grant you the opportunity, to grant you the permission to amend your pleadings at any stage. It could be right at the time of trial. It could be just before you commence the trial and you want to amend your pleadings, and the court shall grant you. And the exceptions are that granting you that amendment at that time is going to prejudice other parties in such a way that that prejudice cannot be compensated by cost, because the court can award cost against you for bringing these amendments in a delayed fashion, or the court could grant an adjournment. If you ask for an amendment at the eve of trial, the court may believe that you may be granted that amendment, but it will be unfair to the parties to respond to that the next day at trial. The court may grant adjournment. So if the court can compensate your delay by awarding cost or by granting adjournments, then the court shall grant it. So generally, the basic principle of amending the pleadings is that the court is required to grant you to make your amendments, because generally speaking, the court wants each party to present their case in the way they want to present it, to set out the causes of action, to set out the facts as they deem appropriate, even if they are coming with those amendments later in the court process. But you want to remember that the basic rules of the pleading still apply. So what that means is, just because you are including something as part of the amendment does not mean that you can do anything with those pleadings. So for example, if what you're asking the court to amend is frivolous or vexatious, the court may not allow it, right? So the rules are the same, that what cannot be included in the original statement of claim will not be allowed to be included just because you are doing it by way of an amendment. Similarly, if your limitations period has expired, then the court may not grant you the amendment because the time to add a party, for example, has expired and the limitations period has expired. So that party may have a valid defense to say that such amendment may not be granted because the limitations period is expired. So there may be, the important point I want you to remember is that the basic rules of pleading still apply to any amendments that you are seeking. Now, how do you amend a pleading? Rule 26.03 covers that. And I'll give you 3 scenarios in which the amendments are possible. First scenario is without the leave or consent, without the leave of the court or consent. So you can just go ahead and have the amendment done and file it with the court. That's the first scenario, the easiest one. The second is on consent of all parties. And then third is with leave of the court. So let's go through each scenario one by one without leave or consent. There are 2 conditions that you need to meet in order to amend your pleadings without consent or without a leave of the court. And the first condition is that the pleadings are not closed. And what is meant by pleadings being closed? I've covered it in another lecture, but Rule 25.05 is the one that describes when pleadings are closed. There's a specific meaning of this word pleadings being closed. And so pleadings are closed when either you have or a party has delivered their reply, so meaning they have served it and filed it with the court, or the time for the delivery of reply has expired. So that's number 1. And number 2, every defendant who is in default has been noted in default. So once these events have occurred, either the reply is delivered and every defendant who is in default is noted in default, the pleadings are considered closed. So as long as the pleadings are not closed, you can go ahead and amend your pleadings. You do not require anyone's permission. Prior to the close of pleadings, you can simply amend your pleadings, go to the court office, and have the registrar issue you the amendment. Now, second condition is that the amendment you are seeking prior to the close of pleadings does not include addition, deletion, substitution of parties. So if it's an amendment that does not include addition, deletion, or substitution of parties, and pleadings are not closed, you can go ahead and amend those pleadings without permission of anyone. On consent, this is pretty straightforward. You need to obtain consent of all parties. So if you want to amend your pleadings, the pleadings are closed at any stage during the court action, you can write to other parties and say, I wish to amend my pleadings, and this is in this form. You provide them with your draft amended pleadings and obtain consent of all parties. And once they provide you the consent, you file that consent with the court along with your amended pleading, and the registrar will amend your pleadings. Obviously, if you do not get the consent of parties, there may be a situation where the party may not grant you their consent. Then you'll have to bring a motion and seek a court order to amend your pleadings. Now, remember that when we're talking about the consent of parties, we're talking about consent of all parties. So if you are adding, deleting, or substituting parties, then you need consent of those parties that you want to add. So if there's a party that you're going to add, which is not presently a defendant or a party in any way, and you want to add that party as a party in that court action, then you require their consent as well. And third is leave of court. Obviously, you can bring a motion under Rule 37, and you ask the court to grant you the amendment that you want. How do you actually make the amendment on the document? So there's a specific way. The rules are very specific in how you make those amendments, and I'm going to go through that very quickly with you, and I'll actually show you a quick example of one of the amended pleadings that I have. So first of all, you have to add the word amended to the title of the pleadings. You have to keep the original issuance date, and then there is another option which is called fresh as amended, which I will show you. But let me see if I can show you a pleading. So this is an example of a pleading. I've taken away the court file numbers and party's name, but you can see here that originally it was a statement of claim and I had amended it. So I've added amended and I've underlined it, which shows that I'm seeking the amendment of this claim. And then whatever the original issuance date was, so in this case it was February 10th, 2016, you keep that. You do not change this date to the current date. You keep the original date as it is, because when the registrar will amend it, the registrar will put a stamp here and then put an issuance date here, which will be the date of the amended statement of claim. But you do not change this date. And if you scroll through, you see that I've added this paragraph, and my client is seeking short-term disability benefits for a certain amount, and this was not previously claimed. So we have added a subparagraph here, and that paragraph is underlined. So every single amendment you make, that needs to be underlined. That's the important part you want to keep in mind. And then similarly, if you scroll all the way down, you will notice that the back pages also take the word amended, and you provide that. And if you are going through multiple amendments, so you made this amendment and then later on you realize that you need to amend it further, then what you have to do is you add another word amended here, and then you put another underline. So 2 underlines will indicate that there have been 2 amendments to the document. 1 underline indicates 1 amendment. So if I have to amend it again, I will add another word here saying amended. So I will, let's say, amended, and so that indicates that it has been amended twice, and underline it, and so on and so forth. So what you want to keep in mind is that one of the tips that you want to keep in mind is that when you are drafting pleadings originally, not the amended ones, you do not want to use underlining at any stage in the pleading. So you will see that none of the headings are underlined, because the underlining in rules is specifically used to show amendments. So if you underline in the original pleadings, then it becomes confusing when you are actually amending the pleading for any reason. So ideally, when you're drafting these pleadings, you do not want to use underlining in your pleadings. Now, fresh as amended is another term that you can use. Essentially what it is if your changes or amendments are so cumbersome that it will be difficult or inconvenient to read that document, then what you can do is you create a fresh document with all the changes that you want. You do not underline anything except that you basically change the title to fresh as amended. So the rest of the pleading will be the same without any underlining because it's a fresh document. But over here, you will create the wording fresh as amended. So that will indicate to the reader that this is a fresh statement of claim which has been amended, and it has been amended without the underlining because by reading through those underlinings it would have been cumbersome and difficult to read. Again, as I said, multiple amendments, you'll have to add additional lines for each occasion, and then do not underline the contents of a pleading unless you're making amendments. Issuance and service of amended pleadings. You take the amended pleadings to the court. The registrar will issue the amended pleadings and put an issuance stamp on it, and then you must serve the amended pleadings on each party, and then you follow the rules of procedure about service, and also about if you were served with amended pleadings, then what do you need to do with respect to any filing of any response or delivery of any response. So again, you need to carefully consider whether you require the amendment or not. Sometimes it's strategic, sometimes it's essential, so you want to consider that. You want to consider the appropriate time for amendment. Do you need to wait till trial? Do you need to wait till the end of examinations for discovery, which may be an opportunity to revisit your case and see whether the amendments are appropriate or not? You want to make sure that you follow the applicable rules, and once you have amended your pleadings, you do it properly, go to the registrar, have it issued, and serve it on parties. So hopefully that explains to you how pleadings are amended under the rules of civil procedure in Ontario. Thank you for watching.